This lesson will be discussing the confidentiality rules and regulations regarding case management services and case management clinical records. We'll be discussing two different federal laws, the HIPAA law, the Health Insurance Portability and Accountability Act, and then also 42 CFR Part 2. In the lesson media, there is a summary of the HIPAA law and there is a summary of 42 CFR Part 2. Additionally, there is a copy of the PowerPoint slides for this lesson. After completing this video and after reviewing the attachments for this lesson, when you feel comfortable, this lesson is completed by taking the quiz with at least a 70% passing score. The Health Insurance Portability and Accountability Act, better known as HIPAA, was passed in 1996. It was the first set of national standards for the protection of the confidentiality of health information. The privacy rule standards address the use and disclosure of individuals' health information, called protected health information, by organizations that are subject to the privacy rule, called covered entities, as well as standards for individuals' privacy rights to understand and control how their health information is used. A major goal of the privacy rule is to assure that individuals' health information is properly protected while allowing the flow of health information needed to provide and promote high-quality health care and to protect the public's health and well-being. The rule strikes a balance that permits important uses of information while protecting the privacy of people who seek care and healing. HIPAA was designed to improve the effectiveness and efficiency of the overall healthcare system. It includes much more than just the privacy provisions. It improved access to health insurance for people who were changing jobs. There was an administrative simplification of the standards for electronic health records. The law also addressed pre-tax medical spending accounts. It set up the National Provider Identification, or the NPI database. But the most recognized aspect of HIPAA is the privacy rule. The privacy rule has two parts. The first addresses the disclosure of a person's medical information. The second part addresses the security of medical information, particularly information that is stored electronically. The HIPAA privacy rule applies to healthcare providers, health insurance companies, healthcare clearinghouses, and business associates of any of these. It provides safeguards by defining what information can be shared with others, how it can be released, as well as how information can be stored, especially electronic storage of records. These regulations describe what information can be shared without a release of information, and also what must be included in a release of information in order for it to be valid. Finally, the regulations describe penalties for inappropriate release of information. These penalties are both civil and criminal. Civil penalties or monetary penalties can be up to $100 per individual incident of failing to comply with the rule, up to $25,000 per year. Criminal penalties for the inappropriate release or use of individually identifiable health information can result in a fine of up to $50,000 and up to 1 year in prison. These penalties increase of up to a fine of $250,000 and up to 10 years in prison if there was intent to sell, transfer, or use the information for commercial advantage, personal gain, or malicious harm. HIPAA defines a number of responsibilities that agencies have regarding the protection of personally identifiable health information. First, the agency has a responsibility to notify its clients, usually in writing, of their privacy rights under the law. Second, privacy policies and procedures must be developed and implemented that are consistent with the privacy rule. The agency must designate a privacy official responsible for developing and implementing its privacy policies and procedures, and a contact person or office that is responsible for receiving complaints and providing individuals with information about the agency's privacy practice. The agency also has a responsibility to train all workforce members on its privacy policies and procedures as necessary for those individuals to carry out their functions. Workforce members include employees, volunteers, trainees, and may also include other persons whose conduct is under the direct control of the agency. The agency must have and apply appropriate sanctions against workforce members who violate its privacy policies. An agency must also mitigate, to the extent practicable, any harmful effect it learns was caused by the use or disclosure of protected health information by its workforce in violation of the privacy policies. The agency has a responsibility to safeguard the data that it maintains. The agency must maintain reasonable and appropriate administrative, technical, and physical safeguards to prevent intentional or unintentional use or disclosure of protected health information. For example, such safeguards might include shredding documents containing protected health information before discarding them, securing medical records with lock and key or with a passcode, and limiting access to the keys or passcodes. The agency must also have procedures for individuals to complain about its compliance with its privacy policies and the privacy rule. The agency must explain those procedures in its privacy practices notice. Among other things, the agency must identify to whom individuals can submit complaints at the agency and also advise that complaints can be submitted to the Secretary of the Department of Health and Human Services. Also included in the agency policies, the agency must state that it may not retaliate against a person for exercising their rights provided by the privacy rule, or for assisting in an investigation by the Department of Health and Human Services, or for opposing an act or practice that the person believes violates the privacy rule. A covered entity or an agency may not require an individual to waive any of their rights under the privacy rule as a condition for obtaining treatment, payment, or enrollment or benefits eligibility. And finally, the agency must maintain, until 6 years after the later of the date of their creation or last effective date, its privacy policies and procedure, its privacy practices notices, the disposition of complaints, and other actions, activities, and designation that the privacy rule requires to be documented. The privacy rule prohibits disclosure of protected health information except as it is permitted by the law or by a valid release of information. The best description of what protected health information is that it is any individually identifiable health information, or information that could be used to identify a particular person. The privacy rule protects all individually identifiable health information held or transmitted by the agency or its business partners in any form of media, whether electronic, paper, or oral. Individually identifiable health information is information including demographic data that relates to the individual's past, present, or future physical or mental health or condition, the provision of health care to the individual, or the past, present, or future payment for the provision of health care to that individual, and that information identifies the individual or for which there is a reasonable basis to believe that the information could be used to identify the individual. Individually identifiable health information includes many common identifiers, such as the person's name, address, date of birth, or social security number. The definition of individually identifiable information is not limited to just the data that might be used to identify the person. That definition of individually identifiable information also includes any information that might be able to be used to identify the person's family members or other members of the person's household or that person's employer. There is a huge list of what is considered individually identifiable information that is provided here on this slide. I'll give you a minute or so to review this list. The HIPAA law specifically prohibits the use or disclosure of protected health information unless certain conditions are met. We are very familiar with the idea of a release of information, and that is the first condition, but I'm going to talk about that on the next slide. Also permitted is the release of information to the individual, and that seems fairly obvious. The last two are much less obvious. HIPAA, number 3, HIPAA permits the release of information for the purpose of treatment, payment, or health care operations. Treatment is the provision, coordination, or management of health care and related services for an individual by one or more health care providers, including consultation between providers regarding a patient and referral of a patient by one provider to another. Payment encompasses the activities of a health care provider or a health insurance plan to obtain premiums, determine or fulfill the responsibilities for coverage and the provision of benefits, and furnish or obtain reimbursement for health care delivered to an individual, and activities of a health care provider to obtain payment or be reimbursed for the provision of health care to an individual. Health care operations include any of the following: quality assessment and improvement activities, including case management and care coordination, competency assurance activities, including provider or health plan performance evaluation, credentialing, and accrediting, conducting or arranging for medical reviews, audits, or legal services, including fraud and abuse detection and compliance programs, specified insurance functions such as underwriting, risk rating, and reinsurance of risk, business planning, development, management, and administrative purposes, and finally, business management and general administrative activities of the agency. The final permitted use is called the Public Interest and Benefit Clause, where the rule allows the sharing of information in a situation where the agency determines that not sharing the information would prevent the provision of timely health care or would be a risk to public safety. The rule specifies those conditions. The first of those is information may be released without the individual's authorization as required by law, including any statute, regulation, or court order. Information may also be released for public health activities, including public health authorities that are authorized by law to collect or receive information for preventing or controlling disease, injury, or disability, and to public health or other government authorities authorized to receive reports of child abuse and neglect. Information may also be shared with individuals who have been contacted or have been exposed to a communicable disease when notification is authorized by law. And finally, to employers regarding employees when requested by employers for information concerning a work-related illness or injury or workplace-related medical surveillance, because such information is needed by the employer to comply with other laws governing the workplace. Information can be shared regarding victims of abuse, neglect, or domestic violence. In certain circumstances, the agency may disclose the protected health information to the appropriate government authorities regarding those victims of abuse, neglect, or domestic violence. Additionally, agencies may disclose protected health information to health oversight agencies for the purposes of legally authorized health oversight activities, such as audits and investigations necessary for the oversight of the healthcare system and government benefit programs. Information can also be shared for law enforcement purposes. Agencies may disclose protected health information to law enforcement officials under the following 6 circumstances. Number 1, as required by law, including court orders, court-ordered warrants, subpoenas, and finally by administrative request. Number 2, to identify or locate a suspect, fugitive, material witness, or missing person. Number 3, in response to a law enforcement official's request for information about a victim or suspected victim of a crime. Number 4, to alert law enforcement of a person's death if the agency suspects that criminal activity caused the death. Number 5, when an agency believes that protected health information is evidence of a crime that occurred on its premises. And finally, number 6, by an agency in a medical emergency not occurring on its premises when necessary to inform law enforcement about the commission and nature of a crime, the location of the crime or crime victims, and the perpetrator of the crime. Additionally, agencies may release information when they believe that it is necessary to release the information to prevent or decrease a serious and imminent threat to a person or to the public when such disclosure is made to someone they believe can prevent or decrease the threat. Agencies may also disclose to law enforcement if the information is needed to identify or apprehend an escapee or a violent individual. And finally, under this section, agencies may disclose protected health information as authorized by and to comply with workers' compensation laws and other similar programs providing benefits for work-related injuries or illnesses. This slide lists all of the information that must be included in a HIPAA-compliant release of information form. I'm going to give you some time to read through all of the items, and then we'll proceed to the next slide. The HIPAA regulations require that an agency maintain a record for up to 6 years after a client has been discharged from treatment of all disclosures that are made regarding the client's personal health information. Additionally, the regulations require that if the individual requests a copy of to whom the disclosures have been made, we must provide a copy of those disclosures. The law allows for some exceptions to a record of the accounting of all the disclosures. So the agency does not have to maintain a record of disclosures that are made in order to carry out treatment or to receive payment. The agency does not have to record information that is shared with the individual about his or her own information, such as if the client requests to review his or her record. The agency does not have to disclose when they release information to other individuals who are involved in the person's care. There is no disclosure of or no record of disclosures made for national security or intelligence purposes. And finally, there's no record of disclosure for information shared with correctional institutions or other law enforcement officers as permitted under the law. HIPAA requires that we provide for reasonable safeguards of the individuals that we serve and their protected health information. The reasonable standard may seem not obvious, but some of the things we don't want to do is to run to our coworker to tell our coworker, "Oh my gosh, you won't believe what I just heard." We don't want to sit down when we get home and share the horror story of the day with our family members. The guide that we need to put in place for ourselves is that we make sure that the only time that we share protected health information about the individuals we serve is for their individual benefit. Some examples of the reasonable safeguard standard are, first, we want to make sure that we set up our rooms so that our voices cannot be overheard outside of the room. That includes individuals who are sitting in the waiting area. We want to make sure that they cannot hear information from the session. Next, we always want to be careful discussing what information about the individuals we serve in public areas. We always have to be aware of who is around and who is in the building. Staff members need to be constantly and consistently reminded regarding the responsibility to protect the privacy of the information that they have. Regarding paper and electronic documents, any documents that have personally identifiable information on them must be stored under lock. Client records cannot be left on desktops or in workstations. They must be under lock. And then electronic information must always be secured under a password-protected file, and computers should be designed to go to sleep when the computer has been left unattended for a certain period of time. An additional safeguard in HIPAA is the minimum necessary standards. This standard states that we may only release the minimum amount of information that is necessary to serve the purpose of the release. For example, if a release states that attendance information can be released, then only attendance record information can be released. We can't release any therapy notes. We can't even discuss anything other than the individual's attendance, because that is the minimum necessary to achieve the purpose of that release. Additionally, the minimum necessary standard requires policies, and those policies must include limitations on who has access to a record, and those limitations must define a reasonable purpose for that individual to have access to the record. And the policies must also list the circumstances that define when a record can be accessed. The HIPAA law also grants clients certain rights. These rights are listed here on this slide, and I want to briefly discuss them. First of all, clients have a right to a written notice of the agency's privacy practices, including an explanation of those rights. Typically, agencies provide the HIPAA privacy practices in a written document that is given to the individual at the beginning of services. The clients have a right to being able to authorize the release of the information, and information cannot be released without their authorization except under specific conditions. Individuals have the right to restrict what can be released of their protected health information, and how their protected health information must be used. Clients have a right to review their medical records. They also have the right to a copy of those records. Clients have a right to be able to make an amendment to anything in the record by submitting a written statement that is typically included with any release of information from the record. Clients have a right to, as we previously discussed, an accurate accounting of any disclosure of information as long as that information is maintained by the program. And finally, under the HIPAA regulations, an individual has a right to file a grievance or a complaint about how their information has been handled by the agency. Another important law that regulates the confidentiality of substance abuse treatment information is 42 CFR Part 2. It protects the privacy of patient records in alcohol and drug treatment programs. It was developed in the 1970s to address concerns of individuals with substance use disorders who were afraid to get treatment for fear that their medical information would be released, possibly leading to discrimination or even prosecution. 42 CFR is much more strict regarding the release or exchange of information than HIPAA is. Releases that may be permissible under HIPAA may be prohibited under 42 CFR. "42 CFR Part 2 applies to any individual or entity that is federally assisted and provides diagnosis, treatment, or referral for the treatment of substance use disorders. Part 2 programs include specialized substance use disorder treatment units and their staff members within general medical facilities. An individual or entity is federally assisted if it is authorized, licensed, certified, or registered by the federal government, or receives any federal funding. Part 2 covers patient records in paper or electronic format that is disclosed by a Part 2 program that identifies the individual, either directly or indirectly, as having or having had a substance use disorder, or as being a participant in a Part 2 program. We should note that Part 2 does not apply to records on substance use disorder patients maintained by the Department of Veterans Affairs. The privacy of those veterans' records are governed under a different law. Under 42 CFR Part 2, programs may disclose patient identifying information in several situations. First, they may disclose information to medical personnel in a bona fide medical emergency. Second, they can release information to qualified researchers, provided the research is subject to the privacy rule under HIPAA. Number 3, they may release information to qualified organizations and persons who are conducting a program audit or evaluation, provided that certain safeguards are met, and those are usually addressed through the HIPAA regulations. And fourth, in response to a subpoena, provided that the court has issued an order authorizing the disclosure that complies with the requirements of 42 CFR Part 2. The Part 2 restrictions on disclosure do not apply to communications among personnel within a Part 2 program regarding patient diagnosis, treatment, or referral for treatment, or between a Part 2 program and an entity that has direct administrative control over the program. Additionally, Part 2 does not restrict disclosure to communications between a Part 2 program and a qualified service organization that provides services to the program. Also, it does not limit releases to communications between a Part 2 program and law enforcement personnel regarding crimes on program premises or against program personnel. And finally, programs are permitted to release information to report incidents of suspected child abuse or neglect according to state laws. Any disclosure of information by a Part 2 program other than those discussed in the previous slide must obtain the patient's written consent to disclose identifying information. Under Part 2, each disclosure made with the individual's consent must be accompanied by a written statement that prohibits the recipient from making any further disclosure of the information unless such redisclosure is expressly permitted by the consent or is otherwise permitted under Part 2. Additionally, any disclosure made under Part 2 must be limited to that information which is necessary to carry out the purpose of the disclosure, similar to what we discussed under the HIPAA privacy rule. Programs that are covered under 42 CFR Part 2 and others who are in lawful possession of patient identifying information, whether in paper or electronic format, must adopt policies and procedures to reasonably protect against the unauthorized use or disclosure of such information and to protect against reasonably anticipated security threats or hazards. Part 2 programs are required to provide each patient with a written summary of the purpose and provisions of the Part 2 law and regulations. This is similar to the notice required under HIPAA regarding the agency's privacy practices. And finally, Part 2 programs are required to give patients access to inspect and obtain a copy of their records. And again, this is similar to the requirements under HIPAA. A significant change was made in a recent amendment to 42 CFR that changed on the consent to release information forms to whom the information is to be released. Originally, 42 CFR only permitted releases or release forms that indicated the name or title of the individual to whom the information would be released, or the name of the organization to whom the information would be released. The recent revision of the law added the ability to include the name of an entity that has a treating provider relationship with the patient, meaning another organization that is currently treating the individual. Additionally, where the law now allows the name of an entity which is a third-party payer. And in a major significant change, 42 CFR releases of information can now include a general designation of individuals or entities such as all my past, present, and future treatment providers. This type of release was previously prohibited specifically under 42 CFR, and it is now permitted. This is the end of the presentation on confidentiality. Again, a reminder, there are some attachments to this lesson, and I encourage you to print and review those attachments. When you are comfortable with the information provided in this presentation and the information in the attachments, You are required to complete the quiz that is attached to this lesson with a passing score of at least 70% in order to complete this lesson.